Hello, hello, back again as we wait. Fans of the fans. Well, she said 10 of, but I know she really meant 2 o'clock, didn't she? Mm-hmm. Hey, Liam, I do agree. Hank is disappointing me. He's pushing this too far. He could lose the jury. It's not a good thing to do on the last witness. I understand he's aggravated. The ARCA thing has been a thing for months and months and months. Well, damn. And I know there's people saying, oh, well, the defense does it all the time. Well, that's them. Like, he needs to be responsible for himself. Who cares what the defense does? Two wrongs don't make a right. Don't be like that. Stop it. What kind of marmalade are you getting, Liam? Thank you, Rocket Couch, for posting the bingos. I appreciate you. I'm glad everybody got a good break. Exactly. He doesn't need to swim in their cesspool. Exactly. Exactly. It's not helpful. The jury is not appreciating it. I bet you he feels good because he's getting his licks in, but, at the same time, it's not doing him any good. It's actually damaging, I think, anyway. But what do I know? You got some fresh air, Liam? I didn't get to go outside. I don't think I would want to. It's like 85. It's a little too hot now. I was gonna go take the dog for a good walk. Well, no, too hot. We will both be sweaty, icky when we go back. He really didn't look like he wanted to go anyway. He's enjoying the air inside. Like orange marmalade with lots of rind. I get lemon, and sometimes the actual the orchard down the road from me, they make marmalades and jams, and they make one that's both orange and lemon, and it's really nice. I like it, and they put a little ginger in it. It's divine. This is like, now the waiting starts. How close to 2 o'clock, when I said that they were going to come back, do you think it's going to be? I bet you it's right at 2 o'clock. They are always like, hey, Rody. They miss hot there. But it's always hot there, isn't it? Like, I'm not used to it. I'm a spring and autumn baby. Like, that's what I like. Like, give me a standard 65 to 70-degree temperature and that's it. Like, I don't want no more, no less. I want it right there, like all the time. I like looking at winter from inside the house.
You are unmuted.
I do like curd, but he actually does a marmalade. It's really nice. Okay, they're back. All right, I'm gonna mute. Let's just let this take over, okay?
Now open, you may be seated.
All right, while the jury is on their way in, I need to see counsel at sidebar.
Of course she does. She's gonna say, "Stop the shenanigans, everybody." Okay, I'm not muting yet until she comes out. That would be sidebar number 8. We are opening with a sidebar. Check it out. Like, what? What? Oh boy. But I don't blame her for pulling them in. Gotta tell them, knock it off. Let's like act like professionals. Just knock it off. I know it's kind of rough. The court is a little bit out of control, isn't it, Maggie? I don't like it. I don't like it at all. And Karen, she's been snarky all day. She's been pushing chairs and making dirty looks. And oh, she's on fire today, too. This whole courtroom is so tense today. Jury's coming in.
Seated, this court is in session.
All right. Mr. Brennan. Jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
Dr. Rentschler, you wrote a report back in February 2024,
That's correct, yes, sir.
and in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
And the x-rays that we looked at or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes.
No
sir.
muscle,
That's correct.
no ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same, no, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the paint test, correct?
Well, I was referring to, there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
I'm going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The
Yes.
question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were, let's see. Uh, 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this.
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 sites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve, as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cuttability and its relation to lacerations severity indices. You know that, you cited that.
That's correct. And it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right. To look specifically at laminated glass and it's the cuttability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct. And that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure. I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Right. Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report, he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover. And then right under that, he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that. And again, that's the only test that he's performed or referred to in this case.
You inferred that.
Inferred that that's how he believes that the arm was positioned.
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position of John O'Keefe when he was hit?
Actually, he doesn't state that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose. But if it's not, again, then I'm not sure what that test actually accomplished or represented.
You've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer. Is there anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alessi?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident.
You
You're correct.
know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree, Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
If you don't have the
You can-
information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
so if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
So if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm gonna, very briefly.
Okay, that was pretty effective. That whole go around there, in this expert's total determination to undermine Dr. Welcher's testing, to where he said there could not be a conclusion because we do not know what position the body was in, and we do not know how fast this vehicle was actually going at the time of any kind of impact, if there was impact. He left it open. He just showed some possibilities where these guys are actually coming down and saying, no, it's impossible, this is impossible, that. So in the go around and them trying to undermine Dr. Welcher, they just admitted that all of their testing is moot because they also do not know what position the body was in. They do not know what angle that arm was at. They do not know the position of anything except for that the car was in reverse and at one point was at 24 miles an hour. 24 was at a speed of 24 miles an hour. Right? That was a long way to go for that, but it was pretty brilliant. In Alan Jackson's all red in the cheeks. All red in the cheeks. This is sidebar number 9. 4 more to go. And we have 2 hours plus. Ooh, no, not 2 hours plus. Under 2 hours, an hour and a half to get to 4 more. And the way it's going, we just might. But this is one of the few sidebars that wasn't called by Judge Cannone herself. They did. They actually think, does you remember Dr. Welcher's testimony? He actually said specifically that there's no, without knowing how the body was and everything, there's so many possibilities that there could not be an actual solid conclusion. There could be plausibility and likelihood, and you could do a lot of tests to show this and that, the other thing. We don't know what happened. We can't put the body in a certain position if we don't know it was in that position.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his pain test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
So when you've made your criticisms that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement by him that he was trying to reenact the actual collision.
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed question is, there is nothing in Dr. Welcher's report or any of his presentation that states he is trying to represent the exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that, is it?
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again, is the answer no?
The answer is no.
When you do crash tests, you have a controlled environment in some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, doctor?
I don't know, is it?
What I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying in part on Dr. Wolf's work.
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift, if a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
Have you seen crash test dummies where it is held in place, electric electromagnetically, and when the collision happens, then the dummy can move. Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before
I
the
have,
impact?
yes.
That wasn't done in this case, was it?
What? It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
Maybe if you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion, and you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Renschel's PowerPoint, please? In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes,
And you put snippets up on the board?
yes,
And these snippets talk about an engagement with the pedestrian in the vehicle?
correct.
Is there a reason why you took out a piece of that article that falls between those two paragraphs?
No, I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet. And these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front end collisions because that is the majority of pedestrian collisions, the front end, isn't it?
The majority, it is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct. And that's why you see a center of mass, you look at the testing we did, that's a center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass, you're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was he, the
24 miles per hour.
No,
Good
it
test.
didn't hit the center of mass of the
Right.
dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle,
So ask the question again.
Okay. you have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
We have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
When you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand,
Yes.
could we see slide 8, please? Okay. Let's try slide 56. You would agree with me, doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
Well, that was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand.
So
But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure if we're talking about force over area. And that's what I evaluated in this case.
when you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
There was a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis, you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data.
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Are those your words?
For a biomechanical analysis, yes, sir.
Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos, E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's
Excuse me, sir. In a collision, have you seen debris fields?
I have, yes.
Have you seen debris fields where a taillight was shattered
I have, yes.
In fact, in your video, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point. Yes, sir. Absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no, you don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of
Could I
an
have exhibit
individual.
73, please? Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of a taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight
Well,
cover.
when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't. Was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir,
Yes.
what I'm asking you is, when you were looking at all the available evidence, did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road? Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't know, sir. I didn't evaluate or investigate that.
Could I have exhibit 76A, please? Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies, that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none. So no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 990. Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that. It refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please. Have you seen this photograph?
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had tail light shards that matched the defendant's Lexus that were removed from his sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't. Well, I believe there was evidence collected like that, but yes.
Okay, could we have 201E, please? Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight,
Yes.
that were recovered from Mr. O'Keefe's sweater or shirt?
Objection.
I'm going to allow that. Did you consider that?
Your Honor, you reformat it. Otherwise, I need to see the votes.
I'll try. I'd rather try to reformat it than come sidebar. Did you know that taillight shards were collected after Mr. O'Keefe's sweatshirt and T-shirt was scraped?
Objection.
I'm going to allow that.
Your Honor, I need to see the votes.
Jurors, this will be brief.
Number 10 coming at you. It's getting heated. It's getting hot in here. Hey. Oh, don't you even start with that buffering thing. Stop it. Just stop it. No, they really don't like they can sit there and pick apart the other expert, but they don't want you to do anything with this, you know? And boy, this snark is like on both sides, tit for tat. Rachel's a hostile. But you know what? Cross-examination is never pleasant. I mean, you know, I don't know anybody that does it like friends. Man, that fan is going fast today. What do you guys in the chat think? You think we're going to reach 13? And we're coming back.
Thank you, Your Honor.
Okay.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his T-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
You are based on what's mentioned, however, but not being finished, the objective will be described based on the question that was asked.
Mhm.
For the same reason I just indicated the sidebar. You just be reformatted. I'll try again.
Mm-hmm.
When you looked at these taillight charts that were objection,
Go ahead, Mr. Brennan.
when we looked at these taillight charts that were consistent with the break in Ms. Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes? Objection. Same objection.
I understand the objection. Word it differently. Start with the different.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keefe's clothes.
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Ms. Reed's Lexus.
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. Without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
Could I have Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you, do you understand
Well, if
that?
that's what you're
I don't
telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to consider in your analysis, forming your opinion whether or not there was a collision between Ms. Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
Do you disagree? Do you think they're not sharp?
I don't have an opinion as to that, sir.
We'll take a look. Objection.
Sustained.
If you look at that for me kindly, can you tell me whether you think those pieces of broken plastic are sharp? Objection.
I would allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than.
Okay, let's go back
Been
to
looking at the normal eye.
20E. Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm, that would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please? Stop. In video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There is not, no,
A drinking glass? No?
no.
In any of your studies, did you have a drinking glass in Randy's hand?
We did not have a drinking glass in the dummy's hand, no.
And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the breaks in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this
Yeah.
test, but you move the arm angle, do you expect that the break would look different?
That the break would look different?
Yes.
It could look a little different. I mean, certainly the breaks looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well,
No, I'm going to allow that.
You do not
How
know
he was
how John
standing that-
O'Keefe was standing that night, do you?
if he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No,
You would not know the exact speed of any vehicle that hit him that night, would you?
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
what do you mean consistent or
Is it
different?
all going in the same direction, or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct?
And you see in your test that the tail light at what you say is 24 miles per hour can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes,
Are they twisting?
they are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, yeah, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the
And
ground.
after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm. You even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking
Yeah.
if you did somersaults and stuff like that.
No, there's no evidence of what he did.
Your Honor, come sidebar quickly before I start.
Okay. Oops.
Oh, sidebar number 11. We're getting really close, really close. I'm going to try, yup. This is number 11 for sure. Thank you, Couch. We're getting really close to 13. We have an hour left before court ends, unless she pulls it. She could call shenanigans and send them all home. You know, the judge can do that. Yeah, it's going round and round. Oh, there was a part there where Mr. Jackson got pretty annoyed that his objections are being overruled. What's fair is fair. And I don't know if we're going to get, I think we will get to be direct. I don't know how much more Mr. Brennan can possibly have. But I've seen stranger things. Yeah, he's trying to save face. All he does is defend what he did. He's not even answering, like, he thinks he's answering the question. Yeah. I just don't know if this is good in front of the jury. Like, I'm not so sure it's gonna play the way Mr. Brennan wants it to in this jury. If you just annoy the hell out of him, you don't. You know, it's a fine line. You don't want to be too soft. You don't want to look like you're badgering. Badgering usually works like, aggressiveness like that only if there is a wrongdoing or something that needs to be exposed, like you know apparently lesson learned. They don't pick on the Commonwealth's experts. But he gonna have you in cross. He does seem to take it a little bit personal today with this stuff. Objection. You are confusing my witness with facts. Exactly. Please don't ask my witness to make a conclusion on the facts or evidence in case. I mean, both sides actually take whatever the witness on the stand says and twist their words to their advantage. They both definitely do that. It's a long sidebar again. I wish I was a fly on the wall. Everybody comes out of the sidebar all like, annoyed too. Hello, Jean. Good afternoon, friend. I'll tell you what, all this go around, I'm looking forward to my nap after stream. And we're back.
Could I have Exhibit 166, please? Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection.
I'm going to allow that.
What is the form of question?
I'm going to allow that.
Your Honor.
So hold on.
Sure.
Let's get an answer, Dr. Mitchell. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
Are you aware of that?
Your Honor, that's not the evidence. That is not the evidence.
So
Glass. not
hold on, Mr. Jackson. Mr. Brennan.
I can reword it.
Objections are worded in a way
You're
to
welcome.
tell the witness how
Are you aware of that
I think
object
it's
that
double
was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Can we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you
Yeah.
know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B,
That's it.
C, D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
98, please. A little more, please. Do you know what that is, sir?
It's hard for me to tell from
Does it
back
look like
there.
a drinking straw?
Okay, the black, that does appear to be a drinking straw,
Have,
yes.
have you seen that before?
I've seen that photograph before.
And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
But was it before you came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
While I evaluated certainly for my report for this case, I don't know if I had known about it prior to that.
Is it mentioned anywhere in the report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay.
Okay, so well, let me wait and wait. Let's just
Yeah,
hope
approach.
it's gonna be nice and calm.
April 20th, 2021. Page 124, line 16. Yes, 124, line 16. May I approach?
Yes.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
And you've testified recently for a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom
I believe I did.
under oath,
Yes, sir.
like the oath you took today?
Yes, or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7.
ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question. And if this is your answer, you should read the answer. Where you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
I have no further questions.
All right, Mr. Jackson? Okay.
Okay. Is that sidebar 12? That's sidebar 12. We're really, 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 really close. Thank you, couch. My hands are full right now. I can't type. Oh, damn. We are very close at 10 after 3. If we go to the court hours of 4 o'clock, we have, we got 15 minutes left. He does not want certain things in. He wants it to be hardly, viciously cast in a much harsher light that is very comfortable for the defense. And the witness is starting to wear down also. This is getting like Granny said in the beginning, is like badgering. If there's not going to be a point, it really shouldn't go on. Though I will admit he made a few points about the evidence pretty clear. Well, here we go.
May I inquire?
Yes.
Thank you. Dr. Rentschler,
Redirect.
you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information. And again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for
So
that.
to get through this, I'm going to let you just
Thank you.
answer the question.
Sorry,
And-
Your Honor.
Rentschler.
And with regard to, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay, wasn't them.
No,
It's a client, correct?
it was a client.
A
That's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Rentschler, where is as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go, you'd go right up. If it was coming right at you and it hits you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the vendor.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not, no.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Renshaw, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection.
Sustained, you have to watch the formal question.
Of course. In your expert opinion, based on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Objection.
Yeah, I'm sustaining that, Your Honor.
In your view, was there evidence of a collision with John O'Keefe?
Objection.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m. Is that your understanding?
Sometime when his body was discovered. That's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge, can I come sidebar?
Okay.
There we go. This number 13. Right? Am I right, Couch? I hope I was keeping up. Yep, bingo. One more. We have a new day leader. Oh boy, oh boy. Do you think he's going to play the clip of Karen Reed talking about pulling it out, the glass from his nose? Thank you. Listen, yes, he didn't, right? He didn't move 80 feet in 36 steps for no reason. That 80 feet was running away from the back of a Lexus Leo. I don't know. Sidebar 12A? No. No, Turtle. It's 13. We don't have no A's and B's. What? Yeah, for the last witness, this is really going on and on. Exactly. You do not have a video of the exact circumstances in most forensic studies. That's true. They really are showing every time, the snarkier his answers get. I was just thinking that, Couch, that during the course of, like, he started out badgering and then he got a little softer and now he's being real direct and he's showing the jury that he won't answer the questions. He will only regurgitate the byline, so to speak. Yeah, he's going to act like there was no glass. There's no scientific evidence that there was glass there. Nope, just all in the evidence. Just like they said, there's no scientific evidence that the taillight came in contact with him, except for all the pieces that are in his sweater or his sweatshirt or whatever that they scraped out of his clothing. Like, yeah, just that. I don't know. I think that was the purpose, to show the bias of the experts. Sometimes experts are giving their opinion based on what they see. All the times they're biased to one answer. And I think that's what he's showing. That's right, Liam. We don't know that the Earth is millions of years old because we weren't there. We were only there for a very short period of time. We have no idea. And I don't have a video of it. I don't. Mm. But you have a book from an eyewitness. Okay, allegedly. All right. Now I'm laughing. Okay. I shouldn't be laughing. It's very serious. It's a murder trial, but I'm laughing because this is getting to the point of ridiculousness. All right, 325 people, and we hit 13. Will we get a 14 or 15 or a 16? Recross continues.
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Uh-huh.
Well, we have the abrasions and then
What
a
about
half
that?
centimeter abrasion. And then we have the laceration and scuff on the left side. And then the skull fracture, it's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
And the
That's the half centimeter. It's not a bruise. It's a half centimeter abrasions, about an eighth of an inch.
looks like
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics, it's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture that doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary. Is one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir?
How did it break that night?
How did, I don't know. There's no evidence of how it broke.
Oh God. Really?
No further questions.
All right.
The dummy
Well said,
broke it
Dr.
like
Lynch.
several
Thank you, Your
times.
Honor.
All right. You're released, sir, from your torture.
Is there an objection? So, subject to us discussing it. Mr. Jackson, subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I'm going to see counsel for a couple of minutes over here.
14. Sidebar 14. There we go. Ding, ding, ding. Ding, ding, ding. We did it. Okay. I couldn't hear which piece of evidence is he talking about. They marked him for identification, but they didn't enter him into evidence. Could anybody make out what he was saying? He was not in front of a mic. And even with my headphones, I couldn't hear him clearly. Anybody catch it? Anybody's headphones and hearing better than mine? Oh, I don't know. Yeah, common sense. The least common of all. I get that. But did anybody hear what evidence he was talking about getting entered in? That she said, nope. It was marked for identification, but it wasn't entered. Exactly, Liam. I remember Welcher saying repeatedly on the stand that there were too many variables of what position the body could be in, or what angle that was hit at. You know, the only thing we know for sure is that it was backing up towards him. There was some plausibility that a side swipe could have been responsible. A side swipe would have broke the taillight with his arm, like Arca graciously showed us. And I don't know. I don't think we're ever going to know exactly what happened. Where do you think the jury is right now in a frustration level between these two guys, huh? Nope, we didn't get to see any clothing analysis. Nope. Oh boy. 10 out of 10, Maggie. I would say that's pretty annoyed. Yeah. I can imagine he didn't. What really gets me is how much they have to ignore to be able to present their conclusions. I mean, they just ignore everything else. This is some sidebar. Long. I don't think we're going to start rebuttal today. I would be surprised if he puts Welcher on the stand with only 20 minutes to go. But I've seen, I think that Judge Cannone should take one look at that jury and let them go for the day. I think they've had enough. His picture did, though, 100% refute the testimony from the dog bite witness. Which picture are you referring to, Liam? He showed directionality of wounds in the opposite direction. He did. Oh, you mean this witness, Rancher? Yes, he did when he described them. Yeah. Is that what you mean, Liam? You see, everybody gets so flustered about everything going back and forth. We miss what actually gets presented. Like, but yeah, you're right. So they're contradicting their own expert witnesses?
Jurors, we're going to release you for the day.
I knew it. There's no way she was
See
going to
you
let them go.
tomorrow morning. Those same cautions, please do not discuss this case.
I'm
with
wondering.
anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
All right, so the jury.
I'm wondering if we're going to have a shootout in the a word out, like a verbal shootout in the courtroom after the jury leaves or not. We'll see. She doesn't really like to do too much of that. I can see it's been a long day. She does. I mean, most judges do. They really should be concerned for the jury, although they have wasted a lot of the jury's time in this court unnecessarily.
May be seated.
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
Okay, 10 minutes and they're going to go over it because
All right, so the court, please.
apparently there's a readjusted PowerPoint date. Oh, that's what Mr. Jackson wants to put into evidence. Okay. When it was put for identification, but Mr. Brennan did not get a chance to go over it. Okay. Oh boy. Because they came up with it so late, Jen. Like, and why would they actually have anything to go? You see, that's the thing. Like, not one single bit of evidence or physical whatever to tie into any of the conspiracy theories that they put out there. They talk about Proctor tampering evidence and framing Karen Reed, and yet there's no evidence of any evidence. There's nothing that leads to any evidence being tampered with. They tried like they could to say that those taillight pieces were placed there because she did not have a taillight accident in front of that house. It happened at John O'Keefe's driveway, like outside of the garage, except there's no plastic pieces there at all. Not at 5 o'clock when it happened. Like, no, you know, they tried to say that it was possibly when they went and picked up the vehicle because he put the wrong time down. No, on cross-examination, that witness had to admit that the taillight looked exactly the same as it did at 5 and 8:30 in the morning when he looked at it directly with the snow on it. And he had to testify directly that he never saw Proctor or Buchanan go near the back of the vehicle when it was being taken away. They had no time to do it. Their own witness. They, yes, Hank Brennan got that into evidence with their own witness. Like, so like where was this framing of evidence that happened? You know? I mean, I'm not sticking up for Proctor. He was lousy. He tainted the whole investigation with his aggressiveness, his bias, and his just really unprofessionalism. So many of them wrote really shoddy reports, you know, but still. Yep, a last minute submission again, Maggie. Always. They don't like to they don't like to obey those discovery rules. Like, they are the worst in Rule 14 violations. And then if Hank Brennan wants to bring something in, they cry like little babies. And yet they're the worst offenders. ARCA should have had their stuff in on May 7th. That was the deadline. And they were granted that as a courtesy from the court after motions and in the hearing. You guys remember? I do. Those hearings were fire. I mean, the hearings before this trial were, whoa. Yep. We always knew that they weren't puncture wounds, although, the XME, Lo Posada, was the only one to call them puncture wounds and say they had any depth. Obviously, she didn't read the report very well, or she thinks she knows better just from looking at a picture. She did not see the body, and she's actually contesting what the other AME said. There was absolutely no depth to them at all. They are not punctures. Yeah, are we gonna blame the dog again, Turtle? Like, this isn't a Bubba moment, is it? Like, no, Bubba didn't do it. Bubba is innocent. Oh, you think it might be the rebuttal report? But that would be put in by Hank Brennan. He does the rebuttal. Defense doesn't do a rebuttal, do they? I'm lost. Or do you mean Rentschler's report about Dr. Wetchler's testing? Did he do a separate report? Is that what you mean? Just rebutting him? Yeah, that's what I think too, Liam, in regards to the wounds. But you see, I think that Dr. Russell had her conclusion before she even looked at anything. I think because of her penchant for dog bite, it's like a passion of hers. She admitted it. That's why she was the perfect expert, because she had been a police officer in a minute, and she's been working in the ER for so long. She's got pathology, you know. She definitely had her determination, her conclusion before anything. And she definitely was just operating with all those years of experience, and I won't take it away from her. She credentialed up the wahoo. However, she reeked of confirmation bias the minute she took that stand. It was all about it being her moment. This is it. This is perfect fit for me. She's the one that contacted the defense. This was confirmation bias. This was not, when she talks about scientific conclusion at all, sorry, not seeing it. I see confirmation bias only. Absolutely. Because, her patterns of recognition, in other words, her methodology is all from her years of experience, and it's in her head. Yep. That's what it translated to me. Sorry if I'm making it like too simple. But I said she's very credentialed, and I wouldn't take any of that away from me. What you'd have, I mean, from her, but I would not. I would be kidding myself if I didn't say I just thought the whole thing reeked of confirmation bias. Like, no independent testing of any type. All of this talk about pattern recognition being the only thing you need to prove that it's a dog bite, right? You got to ignore everything else, right, Liam? Like, where was the dog? Like, what dog? How does the dog leave those kind of marks with no DNA? Even if the dog used a paw to make those scratches, would there not be DNA? That's right. Confirmation bias. Everything she did was just to prove what she thought. And that's what I mean. What she thought. Her, like they said. Yeah, she is literally the only expert in the world on dog bites. You know she's legit. I know she definitely has a high opinion of herself. But I won't take her credentials away from her. I mean, she got a lot of experience. And she's definitely passionate about the dog bite thing. Absolutely. I think the ARCA guys are their attitude was a little bit of sour grapes. I want to remind you all that William Reed, Karen Reed's father, and Karen Reed petitioned for arbiter to take their case uh, before ARCA, before anyone, but they lost the bidding war with the Commonwealth. Arbiter went with the Commonwealth to be their expert witness, and I think it's all just sour grapes from there. Yeah. Unfortunately, I think the defense has got a poor picker when it comes to expert witnesses. Um, Lopasada has years of experience too. But if anybody didn't see that she's built a career the last 20 years based on just testimony, paid testimony, uh, yeah. Her bias came out in questioning too with Hank Brennan. She actually went against their own witnesses too. I'm curious though, what do you think the jury's going to do with the FBI information? Before I met Dr. Russell, I didn't know dogs even had teeth. I know she's helped us all so much, Rocket. Yeah, that's definitely, yep, the defense's impression of an average medical professional. Absolutely. It's pretty funny, actually. All right, her 10 minutes is stretching. Come on back, George Cannone. I want to hear what this is about. And my nap is calling me. The sooner you come back, Judge Cannone, the sooner you can be done with court for the day. So get back in here. Let's get this show on the road. Yeah. So it looks like we're going to have rebuttal tomorrow, guys. And then maybe closing statements in the afternoon. Whoa. And then it goes to the jury on a Friday. Oh boy. That's always like very tense. How are we going to do verdict watch this time? I wonder what kind of notice Judge Cannone will give us to the live feed for verdict. You think we'll get an hour like we did with the last, you know? I don't know. Hello, Sin. How are you today, sir? Since you were last here, we got all our fancy emotes up. We're feeling all fancy. Huh? I'm sorry. Is that not a good day? Long day? Another really harsh day at work? You like the crime one? That's your favorite? We've got some suggestions for making other ones. Mic drop and brain exploding. Like, I got to do a mic drop one. Okay, should that be an otter or a bear? We've got soapbox bear. They did that one. Bear ranting. Has it been a rough week? Oh, hopefully the better half day after today. Like today's Wednesday, so hopefully after today get a little bit better. Sorry about that scene. Well, if you were here, you would have got a lot of word salad and ping pong abuse going back and forth with the attorneys and the witness. It was interesting. Like that's all I can say. Interesting. Although it's kind of wearing on us. Like we're all ready for naps. I think everybody's gonna go just take a nap. I do hope your week gets better though. We're waiting for the judge to come back. Oh, you're not on halftime yet because you got Saturday? Well, actually, since it's the end of Wednesday, it's past halftime anyway. So you actually are. Because now you got Thursday, Friday, and Saturday. And you just hit Monday, Tuesday, and Wednesday. But hopefully it gets better. I really do hope. Yeah. It's always rough when you get that, like, you get that really bad day, you know? You need a good laugh, good sleep, maybe something nice, warm and cozy to eat a little bit, something comforting. But you got to get up and go back there. It's just the drudgery of it all. It's tough. Oh, Monday was a holiday. Oh, what holiday was it? Was it a Memorial Day or something? I can't keep up with all the holidays. Sleep would be good. My nan says a good sleep and a good laugh could pretty much set anything right by the next day. But I don't always get a good sleep. I get a little bit of sleep. Oh, Pentecost. We do Sunday and Monday here in Germany. Oh, okay. Ah, all right. There you go. On Friday, some doctors are going to make me eat some radiation and then take some pictures to figure out why my thyroid is a mess. Oh, Couch, I feel for you. I hope everything goes well. I do know someone who went through that and they got 100%, 100% cured. It happens to be one of the ones that with the direct radioactive intervention can be annihilated. Not that I'm thinking that you have that, because maybe you don't. It might just be a nodule. Ah, I'm sorry you did. See, hopefully everything goes well on Friday, Coach. No, I know it's not treatment, but the treatment is radiation also. I know the testing is the iodine pill for the testing. I'm just hoping that you don't have to have the treatments, but I'm just saying It is like one of the more targeted and successful, very successful treatments. What I'm thinking, maybe just a nodule, maybe nothing. That's I'm sending all the good vibes your way, all of them. I'll be thinking of. Now, if you take the pill, right, and they do the test, you can still be around everybody. You're not going to glow, are you? I know that's silly. It's not scientific. I know the iodine pill isn't going to make you glow. Oh gosh, something inconvenient a week ago? What could you possibly have eaten a week ago that would cancel the test? Like, that's really? No one's told you won't glow? Oh, you had sushi? And so, oh, because of the iodine. I see. Okay. Well, no sushi for you. I'm sorry about the commercials. Why did they put them 3 in a row like that? That's crazy. I've got it on minimal. Oh, it's Twitch. I don't get to say. Sorry, Sin. I have to go in there. I haven't done anything with that. Whatever it was automatically, that's what it is. I have to go and see what I can back down. Yeah, because of the iodine in it, Liam, right? Yeah. Okay, she's taking way more than 10 minutes. It's been 10 minutes since I said it was 10 minutes. This is one thing that definitely Judge Cannone is guilty of. She exaggerates the times. She does. She says 20, she means 40. She says 10, it's going to be 2025. Ooh, king crab legs, the really big one, Roach. I mean, couch. Oh my God. That's terrible. Jeez. Not the crabs, just me messing up your name. That's what I mean was terrible. Sorry about those. I have to check the settings there. I haven't done any settings on ads in Twitch. It kind of caught me by surprise that I got affiliate. So I have to go in there and see what's going on with that. You think they left and just left us sitting up here? Like she changed her mind. She's not coming back. That's the punishment for the lawyers acting up in court today. She's making them sit there and wonder along with us for the next hour, right? King Crown. 3 ads is on the low side. Some channels do 11 at a time. 11 ads at a time? Wow. Sorry. Ooh. That's when you enter in, right? 11 is a lot. I can't even imagine. I don't think I'd sit there waiting to get into chat with 11 ads. "30 seconds for a plastic mat to put on your chair so you can wipe bloodstains off easier." Hey, it's a true crime channel. That was an appropriate ad for the true crime channel. Yay. Twitch is getting with the program. I think so too, Couch. There's like all these slide buttons I got to go check out. Yeah. And they're all at random times, so you can't time it as a creator. No, but I can control frequencies, I think. I'm not used to it at all, Couch. Like I got to get in there and get into all the layers of it. Maybe they are arguing over it. Like, but she said she was coming back to discuss it. Like, where is she? I should be able to time them. You're right, Couch. I think I saw something about that. My voice is at the end of it. Like, she needs to come back. It does come very quickly, Sin. I hope you get some good rest. I hope you have a better day tomorrow, friend. I do. Have a good evening. Thanks for stopping in. Oh, thanks. Yeah, Couch, I'm gonna look at that. Like, when did they do them? In the beginning, in the middle, in the end? Like, I don't know. She was going to go read something. She's gonna be back in 10 minutes. And she told Hank Brennan to look over the presentation. And now we wait. We sit and we wait. Well, she said 10 minutes 23 minutes ago. Mm-hmm. Mm-hmm. Oh my. Well, I think she's still coming back because they haven't cut the feed. And I don't see anything. I guess I'm going to have to go look on the socials. I've been trying to avoid the socials all afternoon, actually. Oh. Let's see. Is she coming back? The first post I see is tofu was yesterday's special. Today it was a ham sandwich. What savory delight will tomorrow bring? Hank Brennan must be hangry. Oh god. Oh my gosh. Oh god. Are they coming back? Hmm. No, they're back.
Put us back in session, you may be seated.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
Exactly the substance of
Which was not objected to, right? But did he object to the PowerPoint coming in?
It's been, we're all under pressure. I don't know what Mr. Alessi did to do, but that's the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it we take it out. these are all the tests that were completed and done, exactly as Dr. Wolf's PowerPoint was done. Dr. Wolf's PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of, the drop test is in Dr. Welch's PowerPoint. There are, most of the videos are included. Oh, no, I'm wrong. Things have slowed down. So the videos are the same, but the videos that Dr. Ridgely used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, which he testified. So what he did, and I remember asking him this before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answer that question for me. Okay, whether they're in evidence or not, and which ones are not regarding the videos.
Is the court suggesting that it's not just the entire PowerPoint?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes,
Very briefly.
yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welchers. I did not object to
Okay.
Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have proposed that objection before it was displayed for the jury.
Well,
The jury has
Not
seen the
true.
entire PowerPoint. I think it's
You did the same thing, Jackson. Knock it off.
If they didn't want to put certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing it before the jury. Given the fact that it's been displayed in, not in part, but in whole, as it now assists for the jury, assists for the court, for quadruple K for identification, it should be admitted.
okay.
Just like Shannon Burgess. It's no different.
All right.
Shannon Burgess's PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay. All right. Is that it for today? Will we see everybody just tomorrow morning? What else do?
Mr. Alessi needs to, I didn't mean to interrupt. Go ahead.
After the defendant rests, we will not be calling any witness, putting on any further evidence.
Okay.
They're not
All
doing
right.
the rebuttal?
Your Honor, it's late in the day. We would like to review motion to require finding of not guilty at the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would it,
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
okay, great. So,
The only technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
no, they were marked as evidence, right?
They're trying to mark as exhibits.
Yeah, they're exhibits.
But no, they're come into evidence, Your Honor. I mean, ruling this-
Are they,
I thought they were marked as identification, not evidence. If they're in evidence, they're in. If it's identification,
So I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, there are exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this word parlance. Yes, it's YYY, ZZZ, AAA, BBB.
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
What number are we at, Madam Court Reporter?
This is definitely a group of people
Okay, and
that
we'll do
have
ABC.
nothing to do with each other again for a while.
So is it Y, Z, A, and B? I think I have. I don't think I have.
I thought he said he wasn't doing any.
Counsel,
he
I'm not sure I
wasn't
have
gonna
those.
take any witnesses. I'm
All
not
right, so
sure.
we will make, so as of now, they're in evidence. Tomorrow, we need to physically put the
Bye, Lucky.
sticker on those.
Can I stick numbers?
Yes.
230A
I'm sorry, say that one.
He definitely needs a
230A
chill pill.
through C. 230C.
He's stuck in Perry Mason mode. He's very aggressive lately. Somebody took away, kicked his puppy or something. I don't know. Something happened to him during this trial.
All right.
If council, there are four,
Four of them,
A through D.
just so the record, this is limited in saying different things. The remark for identification is triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the focal points marking. So as we do that, I'm good, I'll get out of here.
We will do that first thing tomorrow morning.
That's fine.
All right. We will, so everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brennan, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay.
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegated to 1 hour. I would ask. 1 hour and a half.
Council, please, just let this pass.
We're still on 14.
No, I got it, but now you can go.
Oh, that's. I would ask for an hour and a half for a final summation, given the.
Why is that, Charlotte?
length of the case, the amount of evidence that's been adduced. I don't think that's outrageous, and the court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see it out an hour. Let me see. Yeah, you would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the
I
same?
don't have a position, I'll take whatever the defense is.
Let me think about it.
Yes,
All right,
Your Honor.
so we will see.
Thank you.
All right, so I'll see everybody at 10 o'clock tomorrow morning. Is there anything
No,
else?
actually,
we need
it's
to
closing
discuss?
arguments on
We'll
Friday.
see you tomorrow morning.
All rise to court, please.
What do you mean it's never going to be over? We have a charging conference tomorrow and then closing arguments on Friday. Yep. I don't know. Let's just see. Well, on that, everybody, that was it. I'll see you for the charging conference tomorrow. Well, it's going to be a short day and there's no jury, so there's no testimony. It is a nice fan, isn't it, Lucky? And hello. I don't think the jury's going to get it Friday. I think the jury's going to get it Monday. I don't know. Because they take forever to do this stuff and they want to talk for hours. Well, they could get it Friday because if they have to do opening statements on Friday morning, well, the way that she said it, there's going to be charging and statements and arguments, and we'll see. We'll see. They have a whole night to prepare more motions to come in and drive everybody crazy. So let's just see what happens, But on that, I'm off for my nap. I'll see you all tomorrow, an hour later than usual. They're not going to start till 10 o'clock. I'm hoping there's cameras. There should be. Well, we shall see. If there's no cameras, we'll be here for a little bit and then we'll be gone. And we'll just say hello and goodbye. All right. On that, everybody have a good night. Thank you for keeping me company. Don't forget to like, share, comment, please, on the back of those videos. It's like a desert oasis back there lately because we've got live trial going on. So everybody's in here talking to me. Well, don't forget, keep us in the algorithm so we can keep doing this. Go do your due diligence. Thank you. I'll see you all tomorrow.